This time we will consider the minutes from the December 1st, 23 meeting. I would entertain a motion to approve.
So moved.
We also have the typical announcements. Thankful for the First DCA allows us to use this. We know you'll honor their facilities by not bringing food and beverage into the room. And please silence your cell phone if you haven't done it already. I don't think we have anyone, oh, we may have a couple addressing the commission. Please speak up so that we can hear into our recording equipment, and all of the rest of this dais know the same applies. And pursuant to section 286.0114, we know that members of the public have the opportunity to speak, so we would please ask that you let Ms. Fulford, who is sitting in the back, know, and you can fill out a speaker card if you would like to make remarks. First item on the agenda is the consideration of final action, joint stipulation, in re Frank Kruppenbacher. Will the parties or their counsel please identify themselves?
Melody Hadley, Commission Advocate.
Mark Heron on behalf of Frank Kruppenbacher.
For the benefit of the commission, just to remind you, probable cause was previously found on this complaint, so now we have before us a proposed joint stipulation. After we consider the remarks made and the stipulation presented, our option is to approve or to reject the stipulation. If it is not approved, then the complaint would automatically go to the Division of Administrative Hearings, which I'll refer to today as DOA, for an evidentiary hearing, or the parties could negotiate a new resolution. The complainants have the right to respond in writing, but not the right to make remarks at the meeting. Are there any members that need to make a disclosure? Hearing none, Ms. Hadley.
Respondent served as the General Counsel of the Florida Virtual School. The Commission found probable cause to believe that he violated sections 112.3136 and 112.3138 of the Florida statutes in allegations 1 through 6. The case was forwarded to DOA for a hearing. You've heard about DOA's new voluntary mediation process called the Alternative Dispute Resolution Program. It allows the parties a chance to resolve matters with an alternate DOA judge serving as a mediator. In this case, via the ADR process, and with the advice of that alternate DOA judge, the parties were able to come to an agreement. In the stipulation, respondent admits that he violated section 112.3136 Florida statutes by having a virtual school employee perform clerical duties for his private business, and agrees to the entry of a final order recommending a civil penalty of $5,000 with public censure and reprimand. We ask for the allegations 2 through 6 to be dismissed as a part of the settlement agreement. We respectfully ask for the Commission's approval of the joint stipulation.
Morning, Madam Chair, members of the Commission. Mark Heron on behalf of Frank Kruppenbacher. The process that the advocate outlined, this ADR process in DOA, I think is going to be a very helpful process for the Commission to settle cases. I was approached this morning with respect to request to maybe send another one over there. Presentations were made in the ADR process, for those of you that aren't lawyers, to the ALJ that sat in the middle. He heard and was able to guide us in coming to a conclusion that is reflected in the joint stipulation. So we would request that the Commission adopt the joint stipulation of law, fact, and recommended order, and resolve this matter as presented in that stip. Thank you.
Are there any questions from the Commission for Ms. Hadley or for Mr. Hale?
Approval at this recommendation. Second.
Is there any discussion on the motion to approve? Hearing none, all those in favor of the motion to approve the joint stipulation, please indicate by saying aye.
Aye.
Any opposed? It is approved. The Next matter, item 4B, consideration of final action on the stipulation in Ray Beecham. Will the parties or their counsel please identify themselves? Ms. Hadley.
Melody Hadley, Commission Advocate.
Go ahead.
Respondent served as a member of the Noma Town Council. The commission found probable cause to believe that she violated Section 112.3137 of the Florida statutes. Through settlement discussions, the parties have come to an agreement. In the stipulation, a respondent admits that she violated the Code of Ethics and agrees to a final order recommending a civil penalty of $2,500 with public censure and reprimand. I respectfully ask for the commission's approval of the joint stipulation.
Any questions for Ms. Hadley?
Move approval. Second.
Motion to approve the joint stipulation has been seconded. All those in favor, please indicate by saying aye.
Aye.
Any opposed? The motion passes. Next, consideration of final action is on the stipulation in Ray David Law. Will the parties or their counsel please represent or identify themselves? Ms. Hadley.
Melody Hadley, Commission Advocate. In this case, respondent serves as the chairman of the Board of Supervisors of the Coquina Water Control District Board, and he violated Article 2, Section 8H2, Florida Constitution, in Sections 112.3143, 112.3135, and 112.3136 of Florida statutes regarding matters related to the hiring of his son to work for the district. Through settlement discussions, the parties have come to an agreement. In the stipulation, the respondent admits that he violated the Code of Ethics regarding those 4 allegations and agrees to the entry of a final order recommending a total civil penalty of $4,250 with public censure and reprimand. I respectfully ask for the Commission's approval of the joint stipulation.
Thank you, Ms. Hadley. Any questions? Hearing none, I would consider a motion.
Move approval.
It's been moved and seconded to approve the joint stipulation. Any discussion? All those in favor, please indicate by saying aye.
Aye. Aye.
Any opposed? The motion passes. We'll move on now to the advisory opinions. We have 3 today, and as I believe most of you know, but for the benefit of those in the audience who may not, any public officer, candidate for public office, or public employee in Florida who is in doubt about the applicability of the disclosure laws or standards of conduct has the ability to seek an advisory opinion. And today, we may have someone that is here for file 2808. Anybody here? Is the requester here? Would you please stand and introduce yourself? Welcome back, Ms. Hodges. And Joe, you are up. Thank you. Oh, it's not hers? I'm sorry. She's not here.
I was going to clarify, that's for file
Okay, thanks.
2809.
Let's ask the real file 208.
Ty Jackson on behalf of the Legal World Health System.
Thank you, Mr. Jackson. Sorry for the theft identity.
Thank you, Chair. Good morning, Commissioners. This formal opinion request concerns the Lee Memorial Health System, which is an independent special district that operates and maintains hospitals and clinics in Lee County in accordance with 2 chapter laws, Chapter 2000-439 and 2023-326, laws of Florida. It is governed by a board of directors which has requested this opinion. The 2023 law granted the board the ability to convert the district into a nonprofit entity and laid out requirements that would need to be met for the conversion to take place. Those requirements are laid out in detail in the draft opinion. Now, the 2 laws have 4 key provisions that are relevant for this opinion. The first is that the 2000 law permits current system board members to be compensated, and they are compensated. The 2023 law permits the current system board members to serve on the board of the succeeding nonprofit entity if a conversion took place. The third is that the 2023 law is silent on the matter of compensation, thus allowing the nonprofit board members to be compensated as they may be in any other nonprofit organization's directors. Now, normally in this situation, we would consider voting on the conversion with the intent to serve on the board of the succeeding nonprofit entity as a compensated member, we would consider that a voting conflict because that vote would clearly inure to their own special private gain or loss. In that case, we would normally advise them that they must state the nature of their conflict, recuse themselves from the vote, and file the memorandum of voting conflict. But the fourth provision, which is in the 2023 law, states, quote, intent to serve on the board of the succeeding nonprofit entity does not disqualify any member from voting on the proposed conversion, end quote. So it is with this background that the system board asks whether its members may vote on the proposed conversion with the intent to serve in compensated positions on the board of the succeeding nonprofit entity without violating the Code of Ethics. While this commission does not have jurisdiction over the chapter laws referenced, it may consider them as a defense to the application of the Code of Ethics. The requesters are presented with conflicting guidance. The Code of Ethics applies to the requesters generally because they are public officials and states that they may not vote. However, Chapter 2023-326 applies to them specifically because they're named in that chapter law. And that chapter law states that they may vote. Now, it's a well-established legal principle that when a general provision of law conflicts with a specific one, the specific law will control. Therefore, we conclude, the draft opinion before you concludes, that the specific provision which states that they are not disqualified from voting permits them to vote. However, both the Code of Ethics and Chapter 2023-326 require that any potential conflicts of interest be disclosed prior to the vote. Therefore, any board members intending to serve on the nonprofit entity's board must announce that intent at the time of the vote. They may proceed to vote in this case, but must file a Form 8B memorandum of voting conflict within 15 days. I'm available for any questions.
Thank you. Yes, Commissioner.
So they can vote as long as they disclose it. Is that the skinny of the whole thing?
Yes.
Any other questions? Thank you for taking that one apart, and thank you, Mr. Jackson, for the inquiry. I think it was a legitimate question. Is there a motion to approve the advisory opinion?
So moved.
It's been moved and seconded. Any discussion? All those in favor, please indicate by saying aye.
Aye.
Thank you. Thank you both.
Thank you, Madam Chair. Thank you to the staff for the work on that. I know it was a complicated process. We appreciate it.
Thank you. Now we'll move to 2809. Is there anyone here on behalf of the requestor? Let's try it again. Thank you, Sarges. And you're up again, Mr. Burns.
Thank you, Chair. This request comes to us from the City of Jacksonville's Office of Ethics, Compliance, and Oversight on behalf of City Councilman Mike Gay. Approximately 20 years ago, the city began contracting exclusively with Musco Sports Lighting LLC for all of its sports lighting needs at stadiums and parks, et cetera. Partially to standardize equipment and parts across all the city's systems, but also because of their quality and pricing. Now, for approximately 15 years, Musco has subcontracted exclusively with M. Gay Constructors Incorporated, or MGCI, which is owned by Mike Gay. And less than 1 year ago, Mike Gay was elected to the Jacksonville City Council, which clarifies the need for this opinion. And Musco has been subcontracting the installation of its systems for the city of Jacksonville to MGCI for 15 years because it is the only licensed electrical contractor in Duval County that has the cranes, crane operators, drill rigs, electricians, and people with commercial driver's licenses that are necessary to transport the large equipment. The only other qualified installers are from outside of the political subdivision and therefore do not affect the application of the sole source exemption, which is at issue here. Now, at first glance, Councilman Gay appeared to be one step removed from any potential conflict of interest because he would not be contracting directly with the city. He has an employment relationship with his own company. His company contracts with Musco, and Musco contracts with the city of Jacksonville. However, this commission has opined in the past that whenever a service is provided under a personal professional license, a contractual relationship is established between the license holder and the recipient of those licensed services. To comply with regulations from the Department of Business and Professional Regulation, MGCI must perform the work under Mr. Gay's license because he is the only qualifying agent that it has. Therefore, by rendering his professional services through his license, Mr. Gay would have a contractual relationship with the city, which would normally be a conflict of interest. However, the sole source exemption in section 112.31312E states that any potential conflicts of interest under sections 112.313(3) or 7 are negated if the business entity involved is the sole source of supply within the political subdivision and there is a full disclosure by the officer or employee of his or her interest in the business before the business is transacted. While there are no written exclusivity clauses in the contracts between the parties at issue here, there is a well-established pattern of exclusivity in contracting that gives Mr. Gay reasonable notice that a vote on appropriations for city sports lighting would inure to his special private gain or loss. Therefore, he should announce his conflict prior to any such votes, recuse himself, and file a voting conflict memorandum within 15 days of the vote. In sum, however, the draft opinion before you concludes that the sole source exemption applies due to MGCI being the only qualified contractor in the political subdivision, and therefore any conflicts of interest under sections 112.313(3) and 7 are negated. However, it's important to remember that any potential misconduct by Mr. Gay would still be prohibited by section 112.313(6) and Article 2, Section 8H2 of the Florida Constitution. Available for any questions.
Questions, Commissioner Newton? I'll call on you first since I said it.
Throw me out there first. I understand that this councilman, am I right?
Yes, Councilman.
We have to disclose any his voting conflict and not voting, accuse himself. Now, for his company and it's being sole source, would that prohibit him? Wait, my question really is this a blanket pass of doing business with the city? Or is it just for the lights? Because if we allow him to have this because it's sole source, he can go out to other things that he bid on, and use the same entity. You're talking about, I think you said field sports lights. So what about other stuff within the city? I mean, is this case by case, or is it just a silo for just this one?
So the opinion request was very narrowly focused on sports lighting projects. They do have the very long history of contracting for just sports lighting issues, and so the opinion would only apply to that, and it's not a blanket pass to branch out into other areas of business and to just do business with the city.
But you see what I'm saying? I mean, we do this, and that individual, we pretty much exempting from it because of that sole source. They can use that to do this to spread anywhere because now you get that coverage.
Well,
I want to make sure that's not the intention, you know.
He doesn't have that blanket pass. He would only, the exemption would only apply for the
Sports lighting.
Yeah, like large-scale electrical contracting, that's at issue, because he's the only one with the equipment for that, in the political subdivision. So it wouldn't apply to just whatever area of business he wanted to expand into.
What brought me pause is that you, Madam Chair, is that he wasn't on council, but now he's on council. He was already doing this for 15 years prior to getting on council. Now that he's on council, you could also get access to other stuff that you probably know about because you weren't on council. So I'm worried about if we do this just for this, does that give him a pass for whatever he might want to do with the city? That's where I was going.
Well, it sounds that that concern would be covered by the prohibitions under 112.3136 and the disproportionate benefit amendment in the Florida Constitution. That's Article 2, Section 8H2. And so it sounds like the concern you have is that he's going to use his position to sort of aim funds towards other business endeavors besides just a sports lighting thing, but that would still be prohibited under 6 and Article 2.
Mr. Aston? Thank you, Madam.
Thank you. Commissioner Deska.
I'm wondering if I'm missing something. What is the problems and the concerns about abstaining from this vote? Anytime he votes for change this, why is that a problem? I would think as an ethical person, you would just say, I'm out of this one because it's kind of close, it's kind of there. What's the problem?
So I'm not sure I caught exactly what your question was, but are you asking if it's like, why is it a voting conflict if he sees a sports lighting appropriation?
Why is it even asking? I think I'm missing the connection here. Why wouldn't he just abstain from every time they vote on this?
So
Mr. Burst, if you want backup, only if you want it, there's backup.
I think I'm understanding the question, and so I dare to step in. It's not that he doesn't, it's not that he wants to vote here. This is us giving the full spectrum of advice here. This came to us as a conflict of interest question. We answered the conflict of interest question saying he has a sole source exemption. But if we stopped there, and I think it would be incomplete advice, because there are voting concerns that we're aware of that just through what the request looks like. So we addressed voting as well. That's not to say he has a problem abstaining or anything like that. To the contrary, I believe he's well advised by the city of Jacksonville that he has a voting conflict already. So they already knew that. They were advising him of that. So that part of the opinion is not news to him.
Any other questions? Second. It's been moved and seconded to approve the opinion. Is there any discussion? All those in favor, please indicate by saying aye.
Aye.
Thanks, Ms. Hodges, for making the journey, and thanks to the city of Jacksonville for showing up always. The third advisory opinion is file 2811. Is the requester here?
Madam Chair, the requester is here.
Requester is identified as Mark Heron on behalf of,
Madam Chair,
Mr. Zakowski.
and Commissioners, thank you for having me to present this opinion. We were planning on presenting an opinion here today. We may still, but my recommendation will be, after I'm done speaking here, is that we table this for next time. The reason for that is we researched an opinion here, and it's about trusts, and last time I was here, we did an opinion on trusts, and I told you it might be 40 years before we do another opinion on trusts, and we're here again today to do another one. However, as you saw in the materials, there were a lot of facts that were adduced during the request, and we tried to address all of those in the opinion. I became aware today that there is some additional facts, or there's an additional question from Mr. Heron's client that I think I'm not prepared to say that we can answer after this opinion is done, that we could do it by letter. I think it's something that you guys would need to step in and advise on. And so rather than issuing two opinions to this gentleman, I'd rather answer the question that he's got. And I can tell you, Mr. Heron can tell you more about what it is, but I'm not prepared to, I haven't researched on it. I'm not warm on that question. I would love to research it, include it in the opinion, present that to you so we give this particular individual the full spectrum of advice on this particular issue. And my understanding is that the request is not time sensitive. He's got a financial disclosure filing requirement where he will be due to file in July. So if we make this for the March meeting, he still has plenty of time to take the advice, adjust, and remain in compliance with the law. So after Mr. Heron explains what the issue is, my recommendation is that we table this matter for the March meeting.
Thank you. Mr. Heron.
Madam Chair, I concur in everything that your general counsel just told you. The issue that we're talking about that's not specifically addressed in the request is what's the effect of a waiver of trust accounting, which my client has already done. Now, the law says he can revoke that waiver, but it's not necessarily retroactive. So in my consultations with your general counsel, I suggested that we address that issue, move the opinion to the March meeting so that that issue can be addressed fully, since he's not prepared on the fly to give you an opinion on that. Thank you.
You both agree. Is there any objection from the commission? Any other questions? Okay. Yes, please.
I make a motion to table, file, was it 2811? Is that
Yes.
the right one?
Yes.
I'll second.
Any objections? All in favor of tabling till March, please say aye.
Aye.
Any opposed? All right, thank you. Thanks, Mr. Zakowski. Thanks, Mr. Herron.
Thank you, Commissioners.
Right, next up, we have financial disclosure appeals. The first matter is regarding Mr. Albert Cohen, an appeal of the automatic fine assessed for failure to timely file the annual financial disclosure form. Is Mr. Cohen or his counsel here? Right, Mr. Schaefer.
Thank you, Chair. Appellant here is a member of the governing board for the Lincoln Road Business Improvement District, which is a position that requires the filing of a Form 1. Now, this appeal pertains to his failure to timely file a 2020 Form 1, for which he accrued a $1,500 fine. As you can see in your meeting materials, 3 notices were sent to him about his filing obligation for the 2020 form before the grace period expired for that filing year, which happened on September 1st of 2021. There was an initial notice from the Miami-Dade County Supervisor of Elections, then a certified notice from the supervisor, then a reminder postcard from the Ethics Commission. It seems that all 3 of those notices were sent to the same address in New York City, which was at, I believe it was at Ocean Parkway in Brooklyn. The appellant submitted his 2020 Form 1 in January of 2022, which was far enough outside the expiration of the grace period that he accrued the full $1,500 fine, but he has brought this timely appeal. And in his appeal, appellant is arguing that he never received timely notice of his filing obligation for the 2020 form because during the time in question when the notices were sent, he was not present at the addresses where the notices were delivered because he was working remotely due to COVID. This is actually supported by Postal Service records, which indicate that the certified mailing sent by the supervisor's office was just left in the mail slot of the building due to the pandemic. So essentially, he's claiming lack of notice. We have nothing to dispute that claim of lack of notice. And in fact, what we do have supports his claim because it appears he may have received that certified mailing. For that reason, I'm recommending here you find there are unusual circumstances which justify waiving the $1,500 fine that was assessed. I present that order now for your review, and I'm happy to answer your questions.
Any questions? Moved and seconded to approve the proposed final order. Is there any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Motion passes. Thanks, Mr. Schaefer. Next up, we have Philip Maricini. Is anyone here on his behalf? No. Hearing none. Ms. Hayward, would you please make your presentation?
Thank you, Madam Chair. Good morning, Commissioners. The appellant was a member of the Naranga Lakes Community Redevelopment Agency, a position that requires the filing of a Form 1. This appeal pertains to his failure to timely file his 2018 Form 1, for which he incurred a $1,500 fine. As you can see in your meeting materials, many notices were sent to him about his obligation to file the 2018 Form 1, both by the Commission and by the Miami-Dade County Supervisor of Elections. They were sent to an old address of his, however, and he didn't receive the notices, including his notice of his appeal rights. When the appellant contacted the Commission in December of 2021, he informed us the notices had been sent to an outdated address. The Commission sent him a Form 1, 2018 Form 1, and an appeal form. Shortly thereafter, the Commission received his 2018 Form 1 and his appeal of the automatic fine for form year 2018. The basis of his appeal is that he never got notice of his obligation to timely file. Even though the appeal is untimely, I recommend that you treat it as timely, given the fact that the notices, including the notice of his appellate rights, were sent to an outdated address. The appellant says he never received them, and we have no evidence to dispute the claim. In appellant's appeal, he's asking that you waive the fine because he did not receive timely notice of his obligation to file. And we know he did not receive the appeal rights initially. The Commission has found a lack of notice to be a legitimate reason to find that there were unusual circumstances that prevented an appellant from filing their financial disclosure form. Due to the lack of notice, I recommend that you waive the $1,500 fine, and I present this for your consideration. I'll be happy to answer any questions.
Thank you. Are there any questions?
I just one, just if for future, how many of these come before us, but are we required to notify a change of address? And how many people can come forward and keep using this? I mean, the COVID one makes sense. It went into a box and you can sort of link into it, but is there any requirement for us to notify a change of address?
So the law was updated with e-filing so that we're now doing this all electronically through email, and as part of that, there's something in the statute that says that they're required to keep an updated email address with us. This, of course, is occurring before e-filing. This is the 2018 financial disclosure, so this is well before e-filing, so that requirement would not be relevant here. But going forward, as we get years on and we start doing appeals for post e-filing fines, then those issues will slow down and stop happening. You'll see that.
Mayor, just a comment. I fear that's not true. I mean, hundreds and hundreds of emails a day, it's much more. Are we going to be doing still certified notifications in the regular mail, or are we just doing notifications email?
I'm not 100% sure.
I will defer to Kim on this, but it's my understanding that all the notices have to be done by email in the new system. We certainly could decide to do a belt and suspenders approach and do certified mail on top of that, but I agree with you. I think the email,
It's going to be, I get hundreds and hundreds a day. They get buried so quickly. I just think the level of when you get a certified letter, that's very serious. And maybe there's a layered approach there. I know it costs money, but I think you're going to have a lot of people in there that say, I didn't get the email. It went to spam, it went to junk. I didn't see it.
and through the chair, I think it requires that once they miss the deadline, there's a weekly email that goes to them.
Which again, if it's not
To
open,
the bad address.
it just goes to spam and you never open it.
Emails are going to be a big challenge.
Okay.
Yes, Commissioner Newton.
Yeah, I was gonna state that I like going forward, you'll be able to remedy this, because when you were saying 2018, I'm like, that's 6 years ago. It's like, that was almost forever. And also, and I had a problem with that too, because even though you send out certified mail, you can not pick it up and not sign it. Because what I'm hearing is that we proved that the mail was never received, so I don't have to sign it, I can leave it, they can keep leaving notices, and I just let it go back. And if it goes back and you never receive it, so I get a waiver. I think the emails are gonna be more expeditious, because it's gonna require them to keep the email updated, they're elected officials and people that have to do these forms. And then if you start hitting them every week with them, they're gonna see one of them, hopefully. And that should remedy that. And I like that part, because it's got an automatic fine attached to it. See what I'm saying? Even though you didn't get it, or you dodged it or whatever, it still hits you with a fine. And the only time you respond is when you see that fine. When you see that fine, now you're gonna talk to them and say, I want you to waive it because I never got it. But you saw the fine letter. Imagine that. So,
We'll be here for when it happens.
move approval.
It's been moved, it's been seconded to approve the proposed final order.
Second.
Any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? The motion passes. Thank you, Ms. Hayward. Next matters FD 20056, 21003 in Ray Frazier, and number 22013 in Ray Hogu, are matters in which the appellants didn't request a hearing. Are there any members who need to make a disclosure? Hearing none, I would entertain a motion to, if you don't want to hear from staff on this, to accept the proposed orders as a group. It's been moved by Commissioner
Second.
Deskovich and seconded to take these matters up collectively and to approve them. Any objection? All those in favor of the motion say aye.
Aye.
Any opposed? The motion passes. Okay, next up, we have rulemaking on our agenda today, which, requires a public hearing and the opportunity to hear public comment, evidence, and argument about the proposed rule or our changes. And then following that hearing, the commission will have the opportunity to either make changes in response to those comments from the public or any written materials we've received, or we can accept the rule as it's noticed. Or we can withdraw a rule in whole or in part, and I think we'll know better what we want to do after we hear this discussion. We can make technical changes as long as it doesn't affect the substance of the rule. If it affects the substance of the rule, Mr. Schaefer will guide us on whether or not we need to bring it back for consideration at a later time. Mr. Schaefer.
Thank you, Chair. Commissioners, this particular series of rule amendments all pertain to rules in Chapter 34-8 of the Florida Administrative Code. Now, that rule chapter, among other things, sets out and incorporates by reference the Commission's various financial disclosure forms, by which I mean the Form 1 and the Form 6. There are two areas in the rules here that we believe need to be updated. One change is being proposed at your direction based on the discussion at the last meeting about former Commissioner Lyle's opinion request. The other change is more bookkeeping in nature. It's just something we think needs to be tweaked to avoid some confusion for a particular type of filer. Now, turning to the first change, it pertains to attorneys disclosing the names of their legal clients on their Form 6s. If you remember at the last meeting, we discussed a Florida Bar Rule, Rule 4-1.6A of the rules regulating the Florida Bar, that says that an attorney, and this is a quote, must not reveal information related to a client's representation. The Florida Bar calls that the confidentiality rule. Now, the Ethics Commission has no authority, and we discussed this at the last meeting, to interpret that bar rule or to determine how far it extends. But the Florida Bar's Professional Ethics Committee does, and it has issued an opinion indicating that the confidentiality rule might be triggered if an attorney, who is a public officer, discloses the identity of a legal client on a financial disclosure form. Now, just to kind of give you an aside here, there's a difference that I want to clarify between the confidentiality rule and the concept of attorney-client privilege, which I'm guessing most of you have heard of. Attorney-client privilege is a concept found in the Florida statutes. There's actually a law that's been passed about it. And essentially what it does is it protects any communications between an attorney and the client during the course of representation, as long as the communication relates to the matter being litigated, or the matter, I guess, that they're representing them on. Now, the Ethics Commission has issued opinions going back to the 70s that says a statutory attorney-client privilege, which just protects communications, doesn't give a good enough reason for a filer to not put their client's name on their form. It doesn't protect the identity of the client. It just protects communications. But as I just mentioned, the Florida Bar has interpreted the confidentiality rule as going further and deeper. It covers all information related to a client's representation, and the Florida Bar has interpreted that to mean a client's identity. Now, there are exceptions where the identity can be revealed, but in general, that's what the confidentiality rule stands for. It goes deeper than statutory attorney-client privilege, and the Ethics Commission has never written in the context of an advisory opinion about how the confidentiality rule affects disclosures on a Form 6. So that's the context here, the legal context. Now, the Florida Constitution gives the Ethics Commission the authority to pass rules regarding the income requirements on a Form 6, what needs to be put down. And the Code of Ethics in the statute says that the Commission can engage in rulemaking in general about financial disclosure as long as the rules are, quote, not inconsistent with the law, meaning as long as you're not putting a filer in some type of legal violation by the requirements you're passing. Currently, the rule regarding the income disclosure on a Form 6 requires a filer to identify by name each source of income that exceeds the reporting thresholds. Now, those reporting thresholds are fairly high, but they are there, and if you have a particular principal or client that exceeds them, technically you need to write it down on the form. That's repeated in the instructions for the Form 6, as well as for the Form 6F and the Form 6X, all of which are incorporated by reference in this rule chapter. Now, there's a chance here that our rule about income and the instructions that complete the Form 6 are incompatible with this confidentiality rule governing Florida attorneys, because they may place a Florida lawyer completing the Form 6 in violation of the bar rule if they write down and disclose the name of their legal client, assuming that client exceeds the reporting thresholds. So what we're proposing, and this is taking a cue from you all at the last meeting, is that attorneys filling out the Form 6, if they have a client that exceeds the disclosure requirements, should just write legal client in the disclosure fields without providing any further identifying information about that client. This would allow them to stay within the limits of the bar rule by not revealing any identifying information, but they would still at least indicate they do have a client that exceeds the disclosure criteria. Now, this change would need to be made in this rule chapter to the income rule, as well as the different rules that incorporate the instructions for the Form 6, 6X, and 6F. Now, in making this change, we tried to track some very similar language the legislature used when it overhauled the voting conflict law about 10 years ago. 10 years ago, the legislature made a lot of changes to the state code of ethics. One of the changes it made was to the voting conflict statute. And as far as I can tell, it was meant to address this same problem. Now, if you're a public officer and you vote and you have a conflict, you have to file a voting conflict memorandum according to the voting conflict law in which you explain the basis for your conflict. If you're a lawyer who's a public officer and you have a client who could be financially affected by the vote, you have to explain that on your voting conflict form. Now, about 10 years ago, though the legislature made a modification to the voting conflict law, and without going into any details, it basically allowed a public officer who's an attorney to be a little bit more general in disclosing their conflict on the form if it was going to affect a client. Now, we've tried to co-opt some of the exact language used in that modification of the voting conflict law because we thought that it was relevant here in the context of the financial disclosure statute as well. To the degree that possible, we tried to track the language of that voting conflict statute. Now, I do want to emphasize the legislature didn't just let attorneys filling out the voting conflict form off the hook entirely. They still have to complete the form. They can just stay within the limits of the law by not revealing any specific identifying information about their clients. Now, we try to do the same thing here when we're proposing this update to the financial disclosure rules. I think filers should at least disclose the fact that they have a legal client meeting the income criteria. They just shouldn't be required to provide any further information about their client. That would place them in violation of that bar rule. But it seemed to us that letting them off the hook entirely from disclosing anything about their client would not seem to reflect the spirit of transparency behind these disclosure laws. So the amendment is worded to at least make them write something down. It didn't seem right to let them off the hook entirely. Now, if I may, before I move on to the other area of rulemaking, I want to briefly comment on some comments we received about this rule modification. The first commentator was concerned, first of all, that he felt it could be confusing to someone reading the rules whether or not this just applies to Florida attorneys. I will say, though, we feel that it's very clear. The amendment is written in such a way to specifically say it just applies to a filer who is an attorney and who would otherwise be in violation of the rules regulating the Florida bar. So we think that we've reflected that it just applies to attorneys. And that's actually the same language used in the legislature updated the voting conflict law. So if it was good enough in that context, it would seem to be good enough here as well. Also, that same commentator did submit some helpful language, but it omits the requirement to at least write down legal client on the form. We're a little bit concerned about that as well. You know, the whole purpose of financial disclosure is about transparency. We don't just want to overlook that entirely. It seems to us that it would be relevant for the filer to at least write down legal client, just not revealing any more information about that client. Now, the other commentary that we got, the other comments come from individuals who believe that things should stay just the same as what they are. They use the argument that the commission in the past has said attorney-client privilege does not justify not writing your client's name down in your disclosure form. But as I covered, while the commission has addressed attorney-client privilege before, we have never addressed the application of this confidentiality rule. And so I think that is something that we've never considered and that needs to be accounted for here. The second area of rulemaking that I want to talk about is more bookkeeping in nature, a little bit more straightforward. We recently amended the instructions in all of our disclosure forms to indicate that the training certification portion should be completed by elected local officers of independent special districts and anyone who's appointed to serve on an independent special district board. This reflects a recent change made to the training statutes that said these kinds of officers have to start completing 4 hours of ethics training beginning on January 1st of this year, of 2024. Now, while these independent special district officers have to start receiving training in 2024, they technically have the full 12 months of the year to complete that 4 hours of training. And they don't have to certify they completed it until they fill out their 2024 financial disclosure next year and 2025. So it seemed a little bit premature to us then to include them in the training certification portion. And if they're filling out their 2023 disclosure form this summer, they may get very confused if they read the instructions and feel, oh man, I didn't get the training in 2023. Technically, that training requirement didn't kick in for them until this year, so it was a little bit early for us to include them in the instructions. So this is a fairly simple fix. We would recommend that we just remove any reference to independent special district boards from the training portion of the instructions. This change is just temporary. When we finalize the instructions for the 2024 disclosure filings later on this year, we'll be sure to add them back in. If you have any questions about any of these changes, please let me know and I'd be happy to address them. I will say that all of these changes have been duly noticed in the Florida Administrative Register. All this language has been provided to JAPC, and I checked this morning. JAPC has not provided us with any feedback, which I take as a good sign, meaning they're comfortable with the language that we're proposing here. So if you decide to approve these changes today, the only step remaining will be to submit these amendments for adoption at the Department of State. I submit these changes to you now. I'm happy to answer your questions.
Thank you, Mr. Schaefer. Let me ask if there's anyone from the public who wanted to make comments, and then I'll come to the commission members. Mr. Herron.
Mark Herron commenting on behalf of himself. As I understand the changes and how they came about, or the suggested came about from the last meeting, you had a member of the commission that was concerned about filling out on the Form 6 secondary sources of income. I mean, that term wasn't referenced here today, but that's my understanding of what we're talking about. The proposed change, in my view, as a former member of the commission back in the last century, where while the staff may be telling you that it's not affecting transparency, it is. It's like a shade is being drawn over that information when a public official may be voting on a matter and is required to disclose that it affects his client. Now, I heard what Mr. Schaefer said about the legislature changing the voting conflict law to put shade in there too. But again, how are you going to know, how is the public going to know that the matter involves a client that's going to get money in their pocket by an official's vote, even though they do the disclosure? So anyway, that's my 2 cents to putting shade over this thing. It's not fully transparent. I think the cart is going before the horse. Perhaps maybe a discussion with the bar over these issues needs to be done before we go forward with this. But I understand where you're coming from. But again, I think the public is going to be denied access to information that they need to have.
Mr. Herron, only because you're yourself today. And,
Yes.
and Mark Herron, do you mind if I ask you a question? Normally, probably wouldn't do it in a public hearing, but
Anytime.
you're you.
Anytime.
You can take it. So what would you have the attorney who serves on the commission do? I think I know the answer, but just dialoguing in practical terms, if that client is never likely to have anything that intersects with state business or official business, and for many reasons, it would be inappropriate for that client to disclose that, I'm just going to name, a him, let's call him John Doe is the client, and that John Doe constitutes more than 10% of my income. Why is that appropriate or necessary for the world to know in the remote chance that it could be the John Doe that has an issue that happens to come before this commission?
With respect to this commission, probably not. But this rule is not going to apply just to this commission. It's going to apply to all Form 6 filers, okay? So I'll give you an example from the real world of my past. A member of the legislature who's a lawyer in a law firm has a client or more than one client that meets the threshold for disclosure of secondary sources of income. that legislator may be called upon to vote on legislation that specifically affects that client. All the public's going to know is he had a legal client on that deal. Not one client, not that specific client. It's just going to know that. And so that may be information that the public needs to know.
Do you want any questions from anyone else here, or would you like to?
I'll be more than happy to sit down.
Anybody for former Commissioner Aaron before? Thank you. Is there anyone else here who would like to make comments? Hearing none. Mr. Schaefer, would you like to respond?
I would like to respond to Mr. Herron's comments, and very respectfully, I certainly can understand. I think your legal staff and your whole staff at the Commission certainly understands his concern. A couple of things I do want to emphasize, that we are not here this morning about the voting conflict statute. We are just here about the financial disclosure rules, and I just want to make that very clear. I use that as an example because it looks like the legislature has addressed this before in the context of the voting conflict law, but that was already done by law about 10 years ago. So I just want to clarify that what we're asking you today is just going to affect the rules regarding financial disclosure. The only reason I address the voting conflict statute is because it looks like the legislature has already dealt with this in that context, and we thought some of the language could be co-opted because it was helpful. I also want to emphasize this rule change may affect certain clients, but I think our chair alluded to this. The disclosure criteria on the Form 6 is very high. I think that this is just going to affect those who might have to disclose a client of their law firm as a secondary source of income. That's going to mean that the client has to comprise over 10% of that firm's income during the year. It's very conceivable that there are filers who are going to have to grapple with this, but most attorneys are going to work for firms who may not have clients that ever cross that threshold, which probably answers why we've never had to address this before, because it happens fairly rarely. I also wanted to make two other points. Our concern here is that our authority to pass rules about disclosure, or really rules just in general, is that we can't engage in rulemaking if it's inconsistent with the law. Now, we have called the Florida Bar. I personally called them. I did speak with one of their attorneys, and the Florida Bar's position is that a filer is going to be in violation of the confidentiality rule if they identify a client. And as mentioned at the last meeting, the Bar actually issued an opinion saying that as well in the late 70s. So if we are to continue this course without acknowledging this, we may place Florida attorneys between a rock and a hard place, where if they fully comply with our disclosure rules, they're going to be in violation of the law. And that's really what we're trying to address today. One other change that I do want to acknowledge, although this is something that Mr. Herron didn't address, but some of the comments we received did raise it. We have broader rulemaking in this area on the Form 6 than on the Form 1. The Florida Constitution gives the Commission the ability to pass rules regarding income requirements in the Form 6, but it doesn't specifically give us that authority regarding the Form 1. The legislature has actually passed a statute about the income requirements on the Form 1. So if you're curious why my recommendations today are just going to the Form 6 and not the Form 1, it's because we've just been given much clearer authority to pass rules in the context of the Form 6, which is why we have this specific income rule about the Form 6. The legislature's kind of taken up that baton with the Form 1, and our encouragement would be that if this rule does pass, the legislature should be encouraged to amend the Form 1 statute to make a similar reflection for attorneys completing a Form 1.
Thank you. Commissioner Deskovich, did you have a question?
Yeah, just a clarification. You said the language was run by Jeff.
JAPC is the Joint Administrative Procedures Committee. It's a,
Committee that reviews legal language to make sure.
it reviews legal language in as much as it makes sure that we are not operating outside of our rulemaking authority. Again, I submitted this rule packet to JAPC right before Christmas, and I have not heard anything back from them, which in the past has meant that they don't have any feedback on the changes we're proposing.
Commissioner Savant.
So in essence, what we would do is carve out an exception for attorneys that would not be applicable to anybody else, despite the fact I think all of us in our own home location organizations have seen the hue and cry about Form 6 and people saying, I'm resigning my position, yada, yada, yada. Correct?
That's correct.
Do you know of any other professional body, such as the bar, that has this kind of confidentiality requirement imposed on its members?
That's a great question. We have not gone out and researched that. If a particular profession were to raise some type of rule regulating their profession, we would have to address that in that context. This is coming before you based on the discussion, though, like I said, about former Commissioner Lyle's opinion request at the last meeting. He was an attorney. He raised his concern about the confidentiality rule.
Right, and in essence, without this change, any attorney would be faced with the difficult decision he was about which of two things can I do. I cannot do both. I must make a choice.
Like I said, he would be, that per individual would be between a rock and a hard place.
Mr. Newton?
Thank you, Madam Chair. I want to thank Mr. Herron for his testimony. It was showing some clarity of things that I already was pondering. And I got one major question for you. We have over 120 members in the Florida House where I served at, over 40 senators, and I think the vast majority of those individuals are attorneys. How have they dealt with the Form 6 for all these years and never had a problem like we have with the people that's serving on this commission?
The only way that I can answer that question, Commissioner, is to say, again, these reporting thresholds are fairly high. It may not be that very many people had to encounter this before where they had an actual client at their firm that would exceed those thresholds. Because, again, they would just have to report a client exceeding 10% of their firm's income in a calendar year. It may not be that occurred all that often.
Okay, Madam Chair, if I could. You used words like never. So let me ask you, in the history of the Ethics Commission, have there anyone had to disclose the legal clients on the Form 6?
I have not reviewed all the forms that were filed at the commission. I don't know the answer to that question. When I said the word never, what I meant was the commission has never before grappled with the confidentiality rule that we're talking about today in the context of disclosure. We've just addressed attorney-client privilege.
Well, you said never, if I may, Madam Chair, you said never in the content of the dollar amount and the percentage. You said no one has never reached that amount from player we met the player.
Oh, well,
That's
it's
what I meant.
possible
You said
that,
never.
yeah, I understand. It's possible that someone has. I don't know how they would have addressed it because we don't audit each and every form. We would just look at forms to make sure that there's nothing confidential on them in terms of something under Chapter 119 that would have to come out. And then obviously if a complaint is filed about them, that's when we review the form.
See, we have, like you said, authority for rulemaking, but this looks a lot like legislation from the bench because it's all about financial disclosure and transparency. That's what we're about. We're Ethics Commission, ethics. And now we're going to make a rule up where you can not be transparent and not disclose where your finances are coming from. You see, that's where I'm having a tough time with this. You know, serving in these positions that require Form 1s and Form 6 is, in essence, fleas coming with the dog. You want the pretty puppy, but he got fleas on it. Which means if you want to serve in these commissions, they have disclosures for transparencies. I can't come on here and I'm making, I don't know, $20,000 a year, and then next year I got $15 million in my bank account. It won't take a rocket science to figure out where some of that money probably came from. And I think that's why the people of the state of Florida want to know. They want to know. And the reason I brought those first two questions up, because historically we had all those members filing all those Form 6s, including myself. And we just have a problem now because we have attorneys serving on the Ethics Commission that wants to not disclose where their finances are coming from. That's the bottom line. Forget about the client. Because if he wasn't giving them money, he wouldn't be a client. So it's all about financial disclosure of your finances. And you're hearing all this rhetoric around people that are resigning their positions, but you got to ask yourself, have they been using those positions all these years to enrich themselves because they wasn't required to disclose their financial relationships with people that they were voting on that was enriching them, and i.e. they're getting returns, you know? I mean, it's begging the call. But I'm just listening to what we're saying and what we're doing. The other commissioner asked a good question. Is there any other profession that would have to disclose the confidentiality? If a doctor was up here and a doctor receives money from an individual, okay? Don't the doctor have a right to protect his patient's information? I think that's privileged, if I'm not mistaken. A doctor and his patient information, you don't have to disclose that. But he's getting money from them too. So I think that'd be another profession. You say you didn't know of another profession. I think doctors, I don't want to misspeak, but I know they get paid and they don't have to disclose their patients legally unless they're compelled to by a court. But I'm just having a real big problem with the Commission on Ethics. The Commission on Ethics coming up with a way to get around disclosing the finances that individuals are receiving and not reporting on their Form 6. I'm not talking about names, I'm talking about dollars, money, and financial disclosure. So you have to, if you can talk to me a little bit on that, it'll make me feel a little bit better about rule changing or legislation from the bench or whatever we're calling this.
I'll do my best to kind of address your concerns, and we certainly do understand them. In terms of doctors, there very well may be a rule regulating the medical profession. I'm like Steve would say, I'm not warm on those rules. You know, what we try to do here is just address the concern that was raised at the last meeting, which pertained specifically to this Florida bar rule. And I will say as well, when the legislature addressed this in 2013, when it updated the voting conflict law, the only profession that it addressed there was attorneys. So I'm not sure if that's because it didn't account for physicians or if perhaps the intricacies of the laws governing physicians didn't shield revealing identities in certain contexts. I don't know the answer to that. What we try to do here, though, is just address the question that was raised about the bar rule. But if I may, you know, we understand your concern and Mr. Herron's concern regarding transparency. That's why we would strongly encourage you that if you go forward with this, that you at least, at the very least, require them to put down legal client. And I understand that some might argue it's kind of a hollow victory without actually identifying their client, but at least it discloses something on the form. I don't think it would be right for them to put absolutely nothing down on the form regarding a client that they have. Regarding whether or not we are legislating from the Commission's bench, when it comes to legal authority, and that is something that JAPSI reviews, which Commissioner Deskovich asked about before, if we have the authority to engage in rulemaking. But if you look at Article 2, Section 8 of the state constitution, and you look in particular at Section Section I-1, it gives the Commission the authority to pass rules, and this is regarding the Form 6, under which the Form 6 is to be filed, shall be prescribed by the independent commission established early in that subsection, which is you. And it says such rules shall include disclosure of secondary sources of income. So we have been given the specific rulemaking authority in the state constitution to pass rules in this regard. Now again, that just goes to the Form 6. The legislature, because of that, has on its own taken up the baton in the context of the Form 1. It's passed statutes regarding the income requirements in the Form 1. So we wouldn't have the ability to pass rules regarding income disclosure in the Form 1. But in terms of whether or not we're engaging in improper legislation, that is something that JAPSI would have reviewed, and right there in the state constitution, it gives us the ability to pass rules in this regard.
If I may add to that.
Hold on, just one second. I'll let Mr. Zurkowski respond, and then I just want to make sure that we are directing questions to Mr. Schaefer, and then we can have our own internal debate.
Just a follow-up question, if I may, Madam Chair.
Wait, let me say, Mr. Zurkowski had a response.
I agree with everything that Grace said, and Grace covered it really well. I wanted to add to that. I think what your charge here is, and so that you understand exactly what the decision that you're making is, what your choices are. You're really balancing two needs here, two values. On one hand, like you've identified, there's a transparency value that we're all fully aware of, and that we all strive to espouse. The public has a right to know. And then on the other hand, what you have is you have a rule that in practice for lots of people kind of puts them in a gotcha situation. A lot of these attorneys are not going to know what 10% of their firm's income is going to be until they do year-end accounting, which is after the year has ended. So they're in a situation where they're discovering that they are now in a situation that puts them in a situation where they have to name the client on the form, which puts them in violation of the bar rule. The rule creates a gotcha situation, which, if you were asking me, I would tell you is not the hallmark of great rulemaking. And so what we're trying to do is try to put people in a situation where we value and we recognize the right of the public to know, while also balancing with that the hallmarks of good rulemaking, where we don't put people in gotcha situations where it's just a complaint factory, where people are in that situation and they're automatically going to find themselves in a violation before they even have the ability to fix it. So that's what we've tried to do here. You're apt to recognize the values on one side of the ledger, but there's this whole other thing happening on the other side that needs attention.
I have a question, though, before I jump in. And I do appreciate our counsel. That's what always, like, no matter in everything I did in my whole elected career, I always relied on the voice and the recommendation from counsel. That's my get out of jail free card. They tell him what to do. So I appreciate that, and I do believe. Let me offer up a question as an amendment to the, to like you're saying, to not let them off the hook and to put something down in our capacity of rulemaking, and also not run afoul with the bar. Can we amend that to say legal client and put the dollar amount next to it when you say legal client? So that at least the people will know that you got this much money from a legal client, and that way you won't disclose. I don't think there's I don't think there's an attorney-client on the dollar amount. I think it's the name and the work product. But if you can put legal client, if you're gonna use legal client, put dollar amount, so you at least have a finance disclosure.
Now, that's already actually addressed in previous subsections of the rule. The income rule is Rule 34-8.005. We're recommending adding a new subsection to it, subsection 5, which reflects what we're talking about today. Subsection 2 of that rule already says, though, what the requirements are, that you just have to disclose a client exceeding 10% of your business's income in the calendar year. So it actually does go into detail on the dollar amounts earlier in the rule. We aren't touching that part of the rule. With this, we're just adding a subsection out of the end. So what you're talking about is already actually in the parts of the rule that we aren't adjusting today.
But my question was, is it in our preview of rulemaking to, if we use a legal client, can it be a dollar amount attached to that phrase? So anyone looking can know that this is a legal client. You're not disclosing his name, but I got this much finances from this individual, thus disclosing your finances.
Sure.
That's what it's all about, I think.
No,
Disclosure, unless I missed something. Would that be on file with the bar or our rulemaking authority?
May I make an attempt at responding, which is, by virtue of even having to respond to the question, you are indicating that it's more than 10% of your firm's income. Now, whether that ends up being $10,000, $100,000, or $1 million, it's all relative to the total income of the firm. So that's why the percentage amount is what is really triggering here, not the specific dollar amount that would be relevant. Is that correct? That's correct.
When you say detail, you say the detailed dollar amount. What do you mean? Because now the chair is saying something about percentages. I'm talking about, if you said not let them off the hook, they can put legal client, but I'm saying have the dollar amount from who that client was right there, so that people could see that they're disclosing their finances, but not the individual's name, not who it was, and none of that. So that's helped the attorney-client privilege part of it. But the percentage, I mean, how they gonna, a percentage? It could be, I don't know, I'm thinking about income, not just a percentage, a dollar amount. So they would see that she just said 10,000, 100,000, a million, you'll see that. So I'm wondering, in our rulemaking, can we do that?
Commissioner,
Is that in our preview of changing the rule?
Commissioner, when it comes to secondary sources of income like this, they've never had to write a dollar requirement down on the form before. They just have to disclose the identity of the client. And, again, the requirements for disclosing this over 10%, that magic percentage, it's already laid out in the other portions of the income rule, and that particular requirement is fully described in the instructions already on the Form 6. What we're doing is we're just adding an additional sentence underneath that.
I will add,
So you're saying it'll show the dollar amount on the Form 6, that 10% represents? Is that what you're saying?
No, sir. What I'm saying is that in the past, no one has ever had to write a dollar amount down on the form, and the change that you're proposing would not just affect attorneys then, it would affect anyone completing the form. And I think that might add some complexity that's not currently there, and that would kind of spill over just affecting attorneys to affect anyone filing a Form 6 would have to write down a dollar amount in their secondary sources of income.
Well,
Let me let Mr. Zarkowski respond to. Thank you, Mr. Schaefer.
Through the chair, I think your concern is actually addressed halfway. I think that we're talking about secondary sources in the 10% rule, but if the client is a primary source of income to the filer, for example, if they're not getting the money through a firm, but if they're being paid directly by the client, if they're a primary source of income, then that number is disclosed because there's a column on the form for that already. So if they're a primary source of income, it's already set up for the person to disclose the number. So it would be legal client and then the number. On secondary sources, that's where this 10% comes in, which is a different category. So that's what Gray's been talking about, secondary sources. But it is the case that if it was a primary source, the number's already going to be on the form.
and you're saying the entity is already disclosed on the secondary source of income that's over 10%? Currently?
Currently, yes. They
But we
don't,
would let attorneys say legal client and not disclose who the source was.
right.
So therefore, not disclosing what the income was.
That's correct.
So that's the primary reason I'm saying that if you're gonna use that shade, legal source, attach what dollar amount that legal source provided, so that way you won't run afoul with disclosing your financial income, Form 6 financial disclosure. That's what I'm asking about. That's what I'm asking as rulemaking, can we do? That's my question, and I think no one is answering that.
We do have the authority to pass rules regarding disclosure of secondary sources of income. What you're proposing then is if there is an attorney who has a legal client that exceeds the reporting thresholds for a secondary source of income, meaning they comprise over 10% of the firm's income that they work for, that the attorney completing the form just the attorney would have to write legal client and then disclose the dollar amount that that client is paying the firm? That's what you're proposing?
Yes, sir, because only attorney have problems with attorney-client privilege and being fully transparent with disclosure. So like you say, we're not letting them off the hook, we're letting them put legal client in there. But I'm saying, if you're gonna use legal client, that shade, legal client, you're gonna pull that down, it should be a dollar amount attached to that. So we, at least, the people looking to know a legal client provided this much income, and they'll be disclosing their finances, which is required on a Form 6.
So I'm just going to suggest, I think I understand your position and your suggestion, Commissioner Newton. You'll probably, I think, have a position on the overall proposed rule if we're not going to add a financial amount, whether we can or not. I think that is beyond the scope of what we would do today, for sure, is add anything that require a financial amount, because that's more than a technical change. So my suggestion is that we pause just for a second, see if any other commissioners have any questions for Mr. Schaefer, and if not, we can reengage in the merits.
If I will, Madam Chair.
But let me just ask, does anybody else have a question? I need to give somebody else a chance to dialogue. Commissioner Sabone, and then I'll come back to you.
I'm just trying to get an answer, and I can't get an answer from my legal counsel. That's
Yeah, I
all I'm
think-
trying to get, and you're intervening, so you can't answer.
No.
I'm just asking on the rulemaking, can we do that since we're gonna make a shade that says legal client? That's the simple question. I'm asking my counsel, can we do that?
The Constitution gives you plenary authority to make rulemaking on secondary sources of income.
Okay?
So you have the authority to define what a secondary source is, I believe. I'm not sure if it is or isn't in 3144. I can double check that while we're discussing the other matter.
Fair enough,
If there
fair
isn't
enough,
a
fair enough.
statute that covers it, then you might have the authority to do it.
But not today. I mean, would it be more than a technical change?
It's not in the rule as proposed, but as Greg can kind of take you through, there are things that we can do to that potentially. It depends.
Okay, all right, thanks. Commissioner Sabone.
Mr. Schaefer, you may or may not have talked to the bar about this, but I'm wondering if the confidentiality provisions that cause this problem are waivable, and if a waiver would at least give a potential commissioner like Commissioner Lyle some options that he currently does not have.
My understanding, Commissioner Cervone, and I am not, like I said, an expert on the bar rule, and we don't have the authority to give any advice on interpreting the bar rule, but my understanding just from reading it is that there are situations where it is waivable. You know, if the client consents, that would be one example. Obviously, if somebody files a public filing where they identify a client and it's out there that that's your client, I believe that that would also take it out from underneath the reach of the confidentiality rule. I think this is going to arise more in the context of transactional attorneys who might not litigate in court. They might just be hired by private clients to prepare wills or trusts or what have you. I see this arising more often in that context, but you are correct. If there is a waiver from your client, yes, that would take it out from underneath the confidentiality rule. Now, as Steve said, though, a lot of lawyers may not realize they have a client exceeding the 10% threshold until they do their bookkeeping the following year, at which point it'll be too late to ask their client if they would consent to waive confidentiality. So that's the concern here.
Commissioner Disk.
I'm not sure if this is a thought for discussion or if this is, it's going to lead to a question for you all, so I'll bring it up now if you'd rather just close into a discussion. So when I file our 990 every year for the nonprofit, under, I think it's we have a C3 and a C4, but when we do the C4, I think, we don't have to publicly disclose our donors. So like you're saying, legal client, we would say, we do have to put the amount, which I think is a very interesting idea, not for today, but maybe we discuss it. But in one of those, we have to give the IRS the names, but it's not publicly disclosed. And is that an option for us? Is that a discussion later something we're interested in? That way the commission office has the names of them potentially, if there's a problem down the road, we know who it is. But, maybe it's too big of a, maybe we don't want to tackle that, maybe we don't want to hold those names. But there's reasons that the IRS asks that of nonprofits, and it's kind of similar here. They ask, but they also understand that putting something like that out in the public puts those people at risk that are on there, and there's some form of confidentiality there that it keeps. So is this something that we could cross over and use here to solve some of these concerns?
Commissioner, the only thing that I'm aware of here is that a bar opinion, which was written back in the late 70s, that said putting the name of your client down on the form, period, is going to place you in violation of the bar rule. It didn't say, then you can make a confidentiality request to the commission, and it's acceptable as long as you're just revealing it to the commission and they don't release it to anyone else. They didn't really split that hair, and they would then be revealing it to us here at the commission at the very least.
Through the chair, if I may supplement that, there isn't a public records exemption if somebody were to give the commission that information. There isn't a way for us to hold it, and it would just be a public record if it came out, so it would be completely disclosable to the public if we received it.
Got it. Okay. Thank you.
Any other questions for Mr. Schaefer? I'm going to just follow up, even though I think I've heard the answer twice now. As we have considered this matter, and even though I have been one of those who didn't like it the way it was since the very first time I was called to a meeting, as I disclosed at the last discussion of this matter, that I have been in this situation where I think it creates the dilemma for public service as well as private sector business protection obligations. But hearing all of what we've heard today, as well as the comments that were submitted, I would rather err on the side of transparency than being able to protect. I will always honor my obligation to protect the confidentiality, but I just choose transparency over service, meaning I would resign if I got into that situation. But I wasn't, so I was prepared to say, even though I thought this was a good idea before, I'll back away and just leave the status quo for now, and we have to make difficult choices like Mr. Lyle had to make, which was to resign. But what concerns me is I hadn't quite zeroed in on the rock and the hard place. I thought the rock and the hard place was you have to resign if you are going to have to disclose or breach confidentiality. What your chronology has revealed is that you truly could be in the rock and the hard place. It doesn't matter if you resign, because that doesn't eliminate your reporting obligation.
That's correct.
That, to me, if we considered this rule, it's only because otherwise we are in a situation that is irresolvable for the attorney, as far as I can tell, if, and I realize the circumstances might be fairly remote, that not only you in excess of 10%, but that you didn't find it out until the year end, because the filing dates and the collection dates. But I guess I would have looked at it when I have to file, I would look within the last year. And then the next filing date, look within that last year. So the collections for my firm's fiscal year don't necessarily correspond to the Ethics Commission, but when I file, couldn't I just use the last 12 months from the filing date rather than look at year end? I'm trying to find a way to get out of the rock and the hard place from the legal perspective.
When you're completing the income section of your Form 6, it deals with the calendar year,
Okay.
which is why we
I
tell
remember
people on a
that.
Form 6 they can file their income tax return for the previous calendar year. Other portions of the form can be tied to different reporting dates, maybe even a date more recent than the previous calendar year, but not the income portion.
A lot of deep sighs from the. Thank you. That answers the question technically, but doesn't, I think make most of us feel
Doesn't
better.
help.
Got any other wisdom for us? I want to give the executive director the opportunity, just because it's rulemaking, if you have any comments that you wanted us to hear. If not, no obligation.
Thank you, Chair. I would just mention that the issue's been brought up that, if you give sort of this veil of confidentiality to a secondary source that's indicated on the form, that perhaps you want to require that they put a dollar amount on there, and it's been mentioned that maybe that's worthy of discussion, but we couldn't do it today. And I think a change like that, you would want to give notice and give opportunity for people to be heard, because the rulemaking notice only related to this type of language that we gave. And so if you were thinking about adding that requirement to the Form 6, I would suggest that we provide adequate notice to the public where they could be heard on something like that, where the commission could more fully flesh that out and debate it at that time. Related to Commissioner Cervone's reference to resignations in the Form 6 and secondary sources of income, I'll just note that the secondary sources of income section of the Form 6 is identical to the secondary source of income section on the Form 1.
Question for the executive
Yes.
director. Kind of related to that, and considering what I mentioned earlier about we've all seen the hue and cry over the state with people resigning their positions, yada, yada, yada. Have you picked up on anything coming out of the legislature that might impact this?
To answer your question, in terms of secondary sources of income, I have alerted staff in the legislature that we were working with this issue on rulemaking for the Form 6, and if they were so inclined to do something with regard to the Form 1, that would be something that we could not do by rule, and would have to be legislated. So far, I have not seen anything attached to any of our bills or anything proposed, but we're not even halfway through yet, so anything can happen. I'm sure that can be.
Commissioner Cervone, I just wanted to respond to your question or comment about waiving, because on my list of sort of the decision tree that I was writing down of what I would do, the first one was I would ask the client if they would agree to the disclosure. And so then, again, we've shrunk the possibilities that this is an actual problem. But if they didn't want to or wasn't appropriate to ask them, then that doesn't help. But I believe that a client could waive it. I'm not the bar, but from my own ethical review, I believe as long as I have the client's permission, that I could.
I would think so. I would think so.
Commissioner
Oh, are we in discussion now?
Yes, Mr. Schaefer, we'll probably need you again. You're welcome to sit down, but let's go ahead and just continue the internal discussion, and then we can decide whether or not we would like to temporarily postpone the consideration of this, which is what I think I'm inclined to suggest, so that we can consider further both Commissioner Newton's comments as well as the others that we've heard from Mr. Herron, those that commented previously in writing, as well as the commission ideas that we have today, and specifically how they may interrelate to other rules that we see are maybe complicating our consideration of this particular change. Commissioner Dustin.
I'm interested in tabling this today because I think more work mentally needs to be done here on some of these things. But I'm interested in exploring this dollar amount idea for a number of reasons. If there's $2.5 million secondary income on this form, the public at least that perks your eyes up as we get. I'm kind of all over the place. I have real concerns with the transparency, but I don't want to block out attorneys that are highly successful from serving in public office. I think that's not okay either. So I mean, maybe we're all kind of feeling that way. So what can we do? I love the different ideas, but the dollar amount idea, I know it would be probably the hardest to implement, and it's a big idea to discuss. But the public sees a large amount of money there disclosed. They're now going to try to hold that elected leader accountable, at least by pressuring them to disclose the person. They're going to start doing their eyes are going to be on that elected official a little more. That helps a little bit. And so I'm interested in exploring that option.
I'm happy to have it further disclosed. I would much rather give my client's name and fight the bar than I would the amount of money they paid. And I don't think that, I think you will get plenty of public comment if we are starting to talk about those kinds of specifics. I think it has then crossed the line to an invasion of, person's private business, not only the client, but as well as the person who is reporting. Commissioner Newton.
I was just, and I support tabling. As I said, I meant you no disrespect. I was just trying to find a way to satisfy the bar with attorney-client privilege, like Mr. Herron said, and also not just have a shade that gives them pretty much, and that's what our legal counsel say. At least we're providing them to put something in there and not just get off. And that wasn't okay with me, not when it's going to be about financial disclosure. Asking for you to disclose finances. I want anyone that can serve that can serve. But a senator told me once, he said, that Form 6 is going to bring a lot of people pause when they look to try to run against you or do something. And he's right. But in essence of looking at, I think the last count was 125 people statewide that have resigned their positions. But ask yourself, what's so secretive that they had to do that? And some of these individuals probably been in these positions for 10, 20, 30 years. There's no term limits. So you don't know what they've been doing. And now that we want to pull the shade away, I'm getting out because I don't want to do that. And you're right, it is personal, but I can tell you when I was serving in the House, if you want some stuff to keep you up at night, and it's all transparent, go look at each representative or senator's Form 6. We got multi-millionaires serving in the House, okay? Multi-millionaires. And it doesn't have nothing to do with the way they legislate. It's just that they had their family and their businesses. They came into money, and that's okay. But the people want a snapshot of what you got when you come in there to ensure that you're not enriching yourself from that public trust. That's all it says, I think. And I might be wrong, but I defer to my counsel. But I would look at deferring. But if you're going to put a blanket broad statement there that's not a dollar amount, I think that's a little disconcerting on a financial disclosure form. That's why I was saying that, because what that'll do is get an individual, they'll be able to serve without disclosing who that individual is, so thus not violating attorney-client privileges. However, they'll be able to show the income, which is required on a financial disclosure.
Commissioner Stone.
For the reasons the chair mentioned, and also so that we might have the benefit of the missing membership, I move we table.
Is there a second?
Second.
Any discussion? All those in favor of the motion to table this until the March meeting, please indicate by saying aye.
Aye.
Any opposed? The motion passes. Thank you so much, Mr. Schaefer. Mr. Zakowski, I know the whole legal team worked on this, and thank you to those members of the public who contributed their comments, and we welcome them in the future because they're meaningful and they help us see a broader perspective. Moving on to the Commission's annual report, which is something that was in your package once provided, or excuse me, adopted. This report will be provided to the House and the Senate and will be published on the Commission's website. Before I ask for a motion to adopt that, I want to compliment the real, it's already been complicated enough today, compliment the real chair for what I thought was a very well-written and correct letter that she opened with in her statement. I have written that before, and sometimes it just feels perfunctory, but I feel like hers was very significant in terms of the recognition that it provided, that the staff and the executive director and general counsel in particular have been extraordinary in their leadership as well as their service to the state of Florida and to the Commission on Ethics. So with that, I would entertain a motion to adopt that annual report.
So moved.
Second.
Any discussion? All those in favor, please indicate by saying aye.
Aye.
Right, at this time, I will ask the chief, I have no report. No, I don't think the real chair has a report. The executive director probably does.
All right, thank you. I do not have anything to add to my executive director report. So with your indulgence, I'll continue with the legislative report. There are a few things of significance I want to talk about with you. The first relates to Senate Bill 7014. This is the bill you are familiar with. It is a committee bill that is significant in terms of this agency. It includes a couple of your legislative recommendations. That's raising the penalties for in-office and post-office lobbying restrictions to $20,000. That makes it consistent with other civil penalties that we have. Also, for allowing candidates for public office to seek costs and attorney's fees. That was another item that you recommended. So those two things are in this bill. It also makes changes to the term limits that exist for Ethics Commission members. Currently, you can serve a 2-year term. You can be reappointed to that term for another 2 years, and you have to leave the commission. As you know, we've had different commissioners who've been appointed to the commission in subsequent years after taking a break from service. Under this bill, it would be a 2-term limit period, a lifetime limit, if you will. Significantly, the meat of the bill relates to timeframes for complaint processes. Steve and I have worked very hard with Senate staff and leadership on working on the bill that originally gave us 120 days for investigations and 21 days for legal sufficiency. The bill as amended now gives us 150 days to complete an investigation. It gives us the option to bring before this commission a request for an additional 60 days where we can show good cause and with agreement of at least 6 members of this commission, we get another 60 days on top of the 150. Language was also tweaked to allow 30 days for the commission to order an investigation. Steve and I believe that we can be successful as an agency with the terms that would be in the statute, provided that we get some additional staffing and a new case management system. So we are asking for that in order for us to be successful with these timeframes. As you know, we've worked very hard to clear the backlog of cases that once existed and to provide for a more efficient investigative process. And we've been successful in that, but there are always things that can come up in cases that cannot be anticipated. And so we feel like we have some good leeway here. I spoke about a week ago, as well as Chair Lucas, to the Senate rules, and Chair Lucas had a number of items that she wanted to relate pertaining to a part of the bill that would require a minimum 6-member vote to reject an advocate's recommendation or perhaps change a recommendation. So if the recommendation were probable cause, but there were members that wanted probable cause, no further action, instead of a simple majority, it would require 6. Similarly, if the recommendation was probable cause and you wanted to go to no probable cause, it would take 6 rather than a majority. And if it was no probable cause recommended, but you wanted to go probable cause, you would need 6. So Chair Lucas made some comments about that, and I wanted to share those with you today, and she asked that I do that. There are constitutional due process and Florida bar concerns that she shared with implementing this aspect of the bill. The constitutional concerns would be that as appointed members of the commission, you have a constitutional charge to uphold and strengthen the public's trust in their government and to conduct ethics investigations and to make public reports on the investigative findings. There are checks on your authority as commissioners. You're appointed by the heads of 2 branches of government. Governor's appointees go through an appointment and a confirmation process before the Senate. There are term limits. There is a law that establishes a clear process for your removal. And due to the law that passed last year, you'll now be filing a Form 6. Assistant Attorney Generals are not exposed to any of those processes. And although the Commission enjoys the services of 2 highly experienced and competent advocates now, there isn't any guarantee that Assistant Attorneys General in the future who might be assigned to the Commission have that level of expertise or experience, particularly in this type of subject matter, the expertise that it requires to do that job. And the bill, without those kinds of guardrails, would give these assistant attorney generals, our commission advocates, the potential to wield more power than the majority of the full commission in deciding on how the ethics laws are to be applied and decided in the state of Florida. This essentially means that we would expect over the course of every year that many policy decisions that the Commission on Ethics makes will be made by somebody who is not an officer or employee of the Ethics Commission, because a majority vote of Commission members will not be enough to overturn the advocate's prerogative. Logistically, the logistical concerns are that the Commission has 9 seats. We currently have 7 members with 2 vacancies. 5 is our quorum, and we sit here today with a 5-member quorum. Under the language of the bill, with needing at least 6 members present to subvert or change an advocate's recommendation, if it were effective today, we would not be able to later today consider any matters for probable cause. So that might add some additional time to the process. The bill makes an assumption that the advocates will always get these cases right every time, and that it might be the commissioners who analyze these cases incorrectly. And the bill, importantly, allows the advocates only 15 days to review the investigatory case files, research the legal issues, and draft comprehensive and accurate probable cause recommendations. Those recommendations might be a little bit rushed under the timelines created in the bill, but they'll be more consequential than they are currently, and in the collective experience and authority of 5 voting members of the Commission. In terms of due process, the Commission members have the benefit of listening to arguments presented by the respondents at the probable cause hearing or their counsel. Advocates making recommendations will not have the opportunity to hear those arguments when they make their very weighty probable cause recommendations under the bill. In instances where the advocate is we should expect respondents to raise due process challenges, given that they start behind the eight ball before their defense arguments have even been uttered. In many instances, that cake will be baked before it gets argued before the commission. And then finally, relating to Florida Bar professional responsibility concerns, the commission contracts for the services of advocates with the Department of Legal Affairs to procure services to assistant attorney generals to prosecute ethics cases and serve as advocates. The procurement occurs under a legal services contract. The Commission on Ethics is their legal client. The effect of the bill would mean that the attorneys representing the commission might make legal decisions that prohibit the commission from taking certain actions that a majority of the seated members might want to take. It potentially puts the lawyer squarely at odds with the interest of its clients and may, under certain circumstances, create professional responsibility issues for the commission applicants. So you were provided a copy of the bill within your meeting materials along with the amendment that ultimately passed. But I wanted to give you an opportunity to discuss this today as a group because of the significant impacts that it makes and provide your valuable input on any of the issues that I've raised or any other concerns that you have, and give me some input and guidance on this as we move forward. On the Senate side, the bill has passed committees. Its next stop is the Senate floor. On the House side, we do have a companion that has one more stop at State Affairs before it goes to the House floor. I do expect a version of this bill to pass, so the work we're doing between now and the end of session is vitally important to the work of this agency. The effective date is October 1st. That is a switch from July 1st. We asked for that to give us time to plan strategically and structure as appropriate, so when this bill takes effect, we will be able to meet its requirements and not put any cases in jeopardy.
Thank you. Commissioners, start with Commissioner Jessica.
I should try to find the bill sponsors.
In
I may
the
want to give them a call.
in the on the city side, it is a committee bill with Senate Ethics and Elections.
So there's nobody behind it, no person.
As a committee bill, it's the committee.
Chair is responsible for it. And who is that? Do you know?
I know the answer. I think it's Commissioner Russo. Commissioner Burgess. Senator Burgess, thank you.
Commissioner Sabat.
Would it be of any value or assistance to you to have the formal endorsement of the commission for the positions that you and the chair took?
That would be very meaningful. If you all are opposed to the piece of the legislation that requires a 6-member vote to do certain things, I think it's important that you state so on the record. If you disagree with that, I think that's equally important to tell us if you think 6 members is appropriate and needs to use it.
In that case, I would move that we take a formal vote supporting those positions that you enunciated.
Thanks.
Is there a second? I can second that. Is there a better way of doing that, though? Is there I don't know. My nature is, can we put out a public harsh statement about that if we all agree on that? I don't know that a resolution or just a vote, I don't know that has been.
Through the chair, I can think of one other time in the past where the commission met and wanted to oppose something that was very near the end of session. They issued we developed a press release at that time in relation to that because we were in the waning days of session and things needed to happen quickly. We could certainly draft a letter on letterhead that the chair could sign formally stating the commission's position. We could provide that to the committees in the House and the Senate, as well as House and Senate leadership, Senate President and Speaker of the House. We could provide that to them and state these things in writing if you would like.
I'm very much in support of that. I am shocked that our elected officials want to take the authority out of the commission and put it, no offense, into people that aren't appointed by elected officials, or, it's very offensive to me. So I'm in support of whatever action they want to take if everyone agrees, whether it's a letter or a statement. But I think it has to be firm and clear. I mean, no one's going to protect this commission like the people on the commission. Thank you.
Commissioner Saban, did you have a follow-up?
Let me amend the motion to say that we submit a letter to the appropriate people in the House and the Senate affirming the positions that were taken by the chair.
And accompanying the record of the vote.
Yes.
That opposes.
Yes.
Those items in particular with respect to the voting threshold requirement. I think we should write a separate letter saying commissioners can't be reappointed for multiple terms later.
That might, we might have some really wonderful commissioners who have served a couple different times during different decades.
Commissioner Grant, former Commissioner Grant.
Of one, perhaps,
All right.
today's chair.
Any comments, questions, Commissioner Figurs or Commissioner Reed?
No.
If not, okay,
I'm sorry, one more thing. I and this letter that we're drafting, I just want a little more clarity now that we have agreed in a letter. The only thing I am passionate about right now is that 6-member vote. So I don't know if you guys want the letter to address everything in there. The term limits,
Well,
I'm okay. I think that all needs to probably be discussed with them when everyone's here and can have that discussion.
except we're running out of time with session if we do that.
Through the chair, our next commission meeting is on what is supposed to be the last day of session. But as I understand the direction of you in your discussion, is that this letter would specifically address the 6-member vote to
I'm
change
concerned
things.
with the 6-member vote, and I'm concerned with the impact of the timeframes on just being able to effectively process things.
See, if I may, Madam Chair, the bill is already headed to the Senate floor, and the process is, once it's there, they're gonna vote it off the floor. Now, the only other amendment you can get would be somebody on the floor, and the sponsor who's presenting the bill accepts a friendly amendment, because if he doesn't and they don't get a vote, that amendment don't make it on. Now, in this time frame, because the train already left the station, if you start putting multiple things on it, they're gonna kill it. That's what'll happen. They'll shoot the baby, that's what they call it. And that's because you got a commission that went to them with your legislative priorities, and now they are looking to change it midstream. One thing wouldn't be a problem. If the 6 days, I concur, because the people that's traveling to Tallahassee to defend themselves and have lawyers and all that, how are they gonna know 6 people are gonna show up? You know what I'm saying? I had a problem this morning jumping my car. I mean, if we don't make it, then you don't have 6 people like Executive Director just said. You can't act on it. It's like having a quorum. You can't vote without a quorum. So that's gonna be very, very, very problematic when you got 9 members. That's just me on that part, but that's just one thing. I think that one thing can be remedied in this late day and stage in the process. Multiple things I've seen from my experience in the House on that floor is that when they start doing that, they'll table it. And what'll happen, the clock will run out and they'll never take it off the table, and then it'll be next session. And as the ED is submitted, the next time we meet, it's gonna be the last day, and everything will be finalized. They'll be voting on budgets by the time we come back, and they'll be in budget conference. But that's just some input, and I do support the 6 days. But adding a lot of stuff is gonna definitely get it tabled.
Well, I'm fine with just addressing the 6-member vote.
I think then that's the consensus for now, and any commissioners welcome to make separate and independent communications to their members. Just remember that the Sunshine Law applies. I know we all know that to us, but this has been a time where we usually have to be more mindful of that we're not conferring. You can just make your communications separate and directly, or communicate through the chair if you have questions about that. So this time, just to clarify, is your motion, Commissioner Cervone, that...
Madam Chair, before you do that, one more thing I want to interject. Now, nothing stops you, any of us, from, if you got a member on this commission back home that you want to pay a visit, because they do go back and forth home, you can do that and express your
Right.
concerns. So that, nothing won't hurt that, and they can maybe bring it up. But
Right.
I'm saying, on the floor thing, it looks like we can't make up our minds, so they just don't, that's all. Go ahead, I'm sorry, go ahead, Mr.
So I think that's the consensus from Commissioner Servone's motion, just to clarify, tell me if I get it wrong, and seconded by Commissioner Deskovich, is that the chair would be requested to prepare a cover letter that perhaps, if appropriate, accompanies or includes the commission's vote today that opposes in particular the 6-member voting threshold requirement, and otherwise appreciates the legislature's consideration of these ethics issues.
That is precisely my motion.
You said much nicer than I feel inside. But yes, I get that.
Otherwise, we can show up at the rally. All right. Any other discussion on that motion? All those in favor, please indicate by saying aye.
Aye.
Any opposed?
Thank you. I will note that Chair Burgess and the staff there were in a constant communication with Steve and I. Chair Burgess has been great to work with, as well as staff, and I'm sure that he and the other members in leadership will take your concerns very seriously, and we will convey those to them. We'll work with the chair.
Also, Ms. Stillman, if you would convey my second round of compliments and thanks to Chair Lucas for preparing her remarks and analysis.
I will be happy to do that. Real quickly on two other bills that are companions that potentially impact the work of the commission, and those relate to local lobbying registration requirements that are being outlined in House Bill 735 and Senate Bill 734. House Bill 735 passed its first committee yesterday. It creates a new section of law, 112.3262. It also prohibits acceptance of things of value from foreign countries in areas of concern. That's not a problem in terms of adding that restriction. I think you all won't have any difficulty addressing that. But in relation to the local lobbyist registration requirements, the Senate or the House version allows local governments to use the executive branch lobbyist registration form to register local lobbyists. Executive branch lobbyist registration is done electronically now, but it's not mandatory, so there does happen to be an old form that is on our website that local governments could use to register people locally, and that's fine. It gives the commission the ability to accept complaints for a local lobbyist failure to register. There's some technical language there that Steve and I are going to work to clean up. This would put about 2,500 local government entities under a lobbyist registration requirement. The commission would not be registering them. We would be able to investigate the failure to register. However, on the Senate version of this bill, it not only requires local governments to register lobbyists, it requires them to use an electronic system to do so. And there's language in the bill that says if the local governments don't already have an electronic system, they can use the executive and legislative branch system to register their lobbyists. Because we administer the executive branch lobbying laws in the electronic executive branch lobbyist registration system, this is the issue we are working to address, because the electronic system only deals with legislative and executive branch lobbyists and has fields for entry to register those folks. It was not designed for expansion. It was only designed to handle legislative and executive branch lobbyists. It would be a big undertaking to have another IT project to rewrite that system to be able to accommodate the requirements of this bill and do so by its effective date of July 1, especially while we're in the midst of the electronic filing launch, and that is in our heavy season. In addition, the Executive Branch Lobbyist Registration Office is funded by a trust fund. It's an Executive Branch Lobbyist Trust Fund funded by registration fees that are paid. Under the language of the bill, it does not give the ability for the commission to charge for anybody who might use the system. So we've got a little bit of a funding issue there. I have reached out to Senate staff and to the Senate bill sponsor and his staff, and look forward to working with them to accomplish the policy goals, but also be able to implement them. So when I talk to members and staff, generally speaking, the commission has not issued whether or not they support a bill, and so I just share implementation concerns. So that's the other kind of big issue that we're dealing with now, and I'll take any questions on that, and if not, that concludes legislative. And I'll move quickly into e-filing, everyone's favorite topic, and it is the hot topic du jour. As you know, we launched January 1. There was a team of us up early in the morning getting the system up and going with our IT folks, and it was a successful launch. It now includes the local filers, almost 40,000 of us who file financial disclosure. All now will be required to file electronically. Local filers will no longer file their Form 1 with the Supervisor of Elections. It will be filed electronically. The total number of filers registered in EFDMS on or after January 1st of 24 is 845 so far. There were also 87 non-incumbent, non-filer candidates who registered on or after January 1st. So far, we've had 419 Form 1 disclosures filed this year. This includes not only Form 1, but the Form 1X and the Form 1F that can be filed in the system. There have been 72 Form 6 disclosure forms filed. That includes the 6X and 6F so far in 2024. That number includes 21 city commissioners and mayors who are filing the Form 6 for the first time. That's a total of 491 forms e-filed so far this year, and we're not even out of January. Of the forms filed, 32 of those forms had document uploads included in their forms. That's the feature that was added last year, allowing the filers to upload a PDF document with their disclosure. So we are underway. We were very busy in the month of December talking to a lot of city commissioners and mayors regarding the change from the Form 1 to the Form 6, not unlike a little bit of the frenzy we saw with the lobbying restrictions that were implemented at the end of December of 2022. As the date approaches, it becomes a fever pitch. We heard from a lot of people about how they felt about the change. Some liked it, some did not. I think the last number I heard from the League of Cities, who I believe is working to track exactly how many resignations there were, I think the number was 112, but it was still soft at that time. There are 2,600 roughly city commissioners and mayors who'd be filing the Form 6 instead of the Form 1, so that represents less than 5% roughly who had resigned prior to December 31st to file the 6. Right now, agency coordinators are working in the system to update their official filer list for calendar year 2023. That's the 2023 Form 1 and Form 6 due July 1st. There are also folks qualifying for office using the system currently, filing those Form 6s. Individuals who hold reporting positions as of December 31, 2023 are being added to that list. As you know, each agency has a person who provides the commission with the names and contact information and now email addresses for all filers. It's what we use for our official notices. It's a large task. It includes the commission reviewing any names that are a match to an existing name in our system to determine if the person listed is a duplicate filer, or if it's so they can be merged, or if it's a new filer where we have to separate who that person is. There might be 6 John Smiths, and we have to make sure that we are accounting for the correct people. So that's a process in our office. Now that things are done live, coordinators are also entering in new filers who start work and have that first 30-day requirement to file their form. They're entering them into the system so that they can file electronically. As a part of the launch, we launched a new public search that queries the electronic system. This feature has also been an undertaking because we have filers whose forms are now accessible in EFDMS, but they've had their disclosures published previously as a Form 6 that was scanned and published by us. We've also got people now who will file electronically who previously filed with their local supervisor of elections, but their forms were not published and are only available based on a public records request. So once again, a lot of moving parts to launch that search function, and we are constantly looking at ways to improve that. The simplest aspect of the system is the form itself. It's the underpinnings of the process that are complex. Last week, I want to note that the commission was invited by Senators Pizzo and Gruters to participate in a Zoom town hall Q&A of sorts to compare and contrast the Form 1 to the Form 6 and discuss how to accurately disclose certain financial interests on the Form 6. It included a Q&A with the attendees. It was done by Zoom. Steve represented the commission in that endeavor. He did a great job presenting that information, and a recording of that Zoom session is available from a link on our homepage and a link from the electronic page, so anybody who missed it can tune in. We are in a constant education mode. So as you are already aware, the commission will be contracting with a company to provide a call center service in relation to our upcoming financial disclosure season so that we can deal with the uptick of demand on the phone. We started tracking, incidentally, the outreach and assistance that our staff members provide on a routine daily basis. And in 1 week alone, we had 2 commission staff members who had each assisted 100 people in 1 week alone, each of them. So 200 people just out of 2 staff members. So that tells you the level of work that is getting done in your offices. We have worked with the Office of Legislative Services Purchasing Office and their general counsel to develop a request for information and a request for quote that went out for those call center services. And we had a review committee that included CIOs of House and Senate and Legislative Services and members of our staff, and we're currently in the process of reviewing that information, answering questions, and negotiating. We are going to be contacting you to do a Zoom meeting in the near future where you will be able to take up that expenditure because my expenditure authority is limited to $10,000, and we are not quite there in the process to bring it before you at this meeting today. So look for that to come up to be a short Zoom meeting where you'll just be able to take that up. And with that, I am ready to answer any of your questions or conclude my e-filing remarks.
Madam Chair. And it's for the people watching also. I forwarded you an email from Lisa Lozana onto the subject that you were talking about, the housing of the record. It's not with the SOE anymore. It's pertaining to e-filing. The young lady reached out to me and I just sent it over to you. You say you responded to her.
We will respond to her, yes.
So, the first part of the question was, who's going to be the custodian of the record now that the Form 6, now that the SOE isn't? And that's, you probably can answer that one.
Okay. Through the chair, the forms that were previously filed with the local supervisors of elections will still be held by the supervisors of elections. So any forms that they filed in the past are still available as a public record from those supervisors of elections. Anybody who files electronically, those forms are held within the electronic system. That's with the Commission on Ethics. By law, any disclosure form filed in the electronic system is published. So all the forms will be published on our website now, which is different. In the past, Form 1s were not published to the website. They were available as a public record, and we routinely provided those. But now everything will be held electronically. The Commission on Ethics is the repository for those records.
And the second one she asked about was through our legislative priorities, which you just covered some. Would they recommend that they have, each county have an ethics board? We have 67 counties. Currently, how does that work? And is that under the purview of the Ethics Commission?
In terms of local ethics commission, we are not affiliated with any local ethics commissions. We do not have a list of what local ethics commissions might exist. As you know, in statute, agencies are allowed to have some more stringent standards that apply, but the Commission on Ethics does not administer those laws or enforce those laws that are passed at the local level. So some municipalities or counties do have their own. Some places view it as duplicative because we already have a statewide board who does that. And so what we see sometimes is there can be confusion created where people don't realize there's a state commission, or they don't realize they're a local commission, or they get the two confused, or the local might make requirements that appear to be similar to ours. So we deal with that. We deal with that a little bit, but most of the time, all of their business that is done for any type of local ethics commission would be dealing with their local codes or local laws. They do not have the authority to enforce the state code. That is your purview alone.
And that's legislatively? Is that how they get that? The counties from the state?
There is a statute that allows entities to have a more stringent standard of conduct. Their code cannot be in conflict with the state code. It cannot relax any state laws. So
And
it can pass as
my last one, the cases that we dispersed with, people, like we did a couple, people off of settlements and we're approving this morning, when they go over, I guess, to the governor, is there a tracking of which ones were closed or acted on? Or do we have a record of that, or how does that work?
Through the chair, the imposition of penalties, most of which now are done through the governor's office. Years ago, it was done by the local boards or local supervisors, and it got to be where they weren't really enforcing or imposing any of the penalties that the commission recommended. Those now go to the governor, included with my executive director's report, as we have done for many, many years. We have a list of the recommended penalties that you all have made, where we are awaiting the imposition of penalties, and then I share with you the executive orders, as I did this time, of any cases where the governor has imposed a recommended penalty, or any other enforcement authority has let us know that they have imposed a recommended penalty. So we do keep track of that internally, because once those penalties are imposed, then the advocates can collect civil penalties, and they move on that.
The reason I brought that up, it came to my attention that there were several that have not been, I mean, quite a few of them, and I'm wondering if we're tracking that, because I haven't seen anything on it, as to did the government impose the fines that we suggested, or people paid? And I'm wondering, because that is some revenue for them, I'm wondering why, if not, why not? And do we have a tracking on when we send stuff, what happened to it, or is it just sitting somewhere and eventually something will happen, or someone will term out or leave office or whatever? That's why I'm asking, because I don't know what happens after you leave office.
Through the chair, the executive director's report, the written report that's included with your meeting materials, has an accounting of what is still pending. Anytime that a civil penalty related to a complaint is imposed, it goes to the advocate. They can get court judgments for collections of those civil penalties, and they have a great track record of collecting anything that's not been paid. Generally, they're paid. We do keep track of that.
Okay, I didn't know, I just was curious. That came to my attention, and I thought, I didn't know if I know we're sending them up. I know people are having stipulations and agreeing and stuff, but is it being paid, or are we collecting it, or is it just or it's stuck in a pipeline? That's what I was trying to figure out. I haven't seen anything. I don't know. So in your report, it'll show who's been paid, who's paid, and who hasn't paid, or what's been done with it, other than just awaiting House action or Senate action or governor's action, is that, because I've seen that report.
Right. I do not include who's paid or who hasn't paid relating to complaints. I track whether or not the penalty has been imposed by the authority who can impose the penalty. Once it's imposed, I provide a copy of that. In the governor's case, it's usually an executive order. In the House or Senate, it might be the journal pages, or it might be a letter that they share with us to provide you with that information. The advocates get a copy of the letter, a copy of the executive order, and then they proceed with collection efforts. I don't want to put Buff on the spot, but I am not aware of any particular fines that might be outstanding or unpaid at the moment. But if you could maybe enlighten us, if there are some that you're pursuing?
We are assigned the job of collecting the penalties. It's frequently not easy to do, but it's a task we work on those daily. I'm happy to report that one penalty was just paid because we put a judgment or a lien on someone's home, and it was a $14,000 penalty. We are now seeking about a 20-year-old penalty owed by someone in New York, and we're domesticating our judgment to put it against some of the properties owned by that former public employer who now lives in New York. We are constantly working on collecting the penalties. We do have outstanding cases, but we are actively working on getting judgments on those. And then we're constantly reviewing ways we can get the money through other means. We now have a public records request with the Department of Highway Safety and Motor Vehicles to see what vehicles are owned by the individuals who owe money so that we can put liens against the vehicles.
You should partner with child support. They can find everybody. I'm serious. All their valuables.
We can find them, but we can't get them to pay. But we are actively working on that.
Yeah, I was just curious, because, I mean, we do this, and if we're just doing it, and people are accepting settlements, and we're putting fines, and they're just sitting somewhere and not being collected, and people are leaving the office and doing whatever, I'm saying, what's the point?
Through the chair, no, sir, we are working on it, actively working on it.
And I keep hearing revenue, and we got to meet for revenue, and I'm thinking that's revenue, and
And the money goes into the general revenue.
which funds us, or funds, yeah, okay, thank you. Thank you, Madam Chair.
Thank you.
You're done. All right, that was quite a report. Any other questions, comments from the commission? If not, is there a motion to adjourn?
So moved.
All right, we are adjourned. Thank you, and let's meet back here at 10 minutes after 11. Fair?
Yep.
You need to drink water.
Now that you have 5 members, you're going to have to provide a bill diapers. And the chair just drives us right through. What? Drives us right through.
I notice how when I'm not choosing, when I'm not choosing, attention today, so normally I would have had to go. Well, the unfortunate thing is, like the last